Hi everyone, thanks for joining our live stream. We're going to be talking about EB-1A final merits on this one. We can give everyone just a couple moments to kind of settle in. Feel free to start asking questions right away on this one. I really just have a brief presentation just to go over the topic, but I think questions will be a really good way to parse the subject. I get a lot of assessments. So Waypoint does a bunch of free assessments for EB-1A. I also do a lot of consultations for people who are on various stages of the profile building journey. And final merits is something that I think everyone has a bit of a different conception of. And that's fine because it's a really, really vague concept. It's not well defined in the law. But there are a bunch of different approaches that I think are not quite right. And that's what I'll kind of go through on this live stream today. A lot of people who are working on final merits tend to treat it like it's an 11th criteria, but not an optional one. It's one that they have to meet. And while it's true that you do have to prove the final merits, it's not really a criteria like the other USCIS criteria are. There aren't points that you have to hit. There are not activities that you have to do. Final merits is really about demonstrating that you have risen to the top of your field. And sometimes there's one thing in your profile that you'll be emphasizing for final merits and nothing else. Like final merits is not really where you should dump extraneous evidence or things that don't fit into the criteria. If you do that, you might end up presenting your weakest evidence with final merits, and that's definitely not what you want to do. Because this is where you prove that you've risen to the top of your field. So you want to emphasize the strongest points in your case here. If you've claimed 6 criteria, but only 2 of them are really, really strong, and you have really strong leading role, really strong high salary, such that anyone around you in your industry would point to you as being a top expert in your field and having risen to the top of your field, those are the points that you want to emphasize in final merits. You don't necessarily want to emphasize all of your published articles or your judge roles. You don't want to mention, BCS fellowship. You don't want to mention a couple of media publications you got published in. You want to focus on the leading critical role in the high salary, and the high salary is essentially just objective evidence that your skills are being really highly valued in the workplace. That is an indication that you are at the top of your field. So sometimes in final merits, I just discuss those 2 points, and then I list a bunch of expert quotes where top experts are recognizing you as being in the top of your field. With that approach in mind, again, it's not about hitting certain check marks. It's not about putting in additional evidence or additional items or additional profile building activities. Final merits should be one of those parts of the case where you take a step back from everything and you ask, okay, what would an average American, a reasonable person, think makes me qualified for this category? And that is the argument that you want to make for final merits. It's really short, little spiel here. So I do want to open it up for questions. I'm really happy to answer any questions on final merits. If you have questions about the criteria, go ahead and throw those in as well. But go ahead and start. Jason, while people are kind of coming in and asking questions, have you seen final merits questions floating around? Have you heard chatter about how people are talking about this? Anything you want to jump in and ask about here?
So a lot of people want clarification on what it means for activities to help with final merits.
Mm-hmm.
What I tend to tell them is that something you can do is for any activity you do, maybe ask other top professionals in your field if that specific activity makes them think that you're a top professional.
Mm-hmm.
Sometimes the answer is no. If it's like a random publication or like a random job option.
I think that's a really, really good approach in general, because it does matter. In the final merits, what matters is what I call the prestige factors, right? These are the factors that people will look at to objectively say, oh, that person is admirable, that person is at the top of your field. And so if you're taking this approach, like just like Jason outlined, if you are approaching other top people in your field that you admire, that you consider to be at the top of their field, and asking them what their opinion is, that's going to weigh really heavily. And they'll probably pick, various profile building activities. If you do give them a chance to weigh in, they'll probably pick ones that USCIS will also find to be impressive. And even if USCIS doesn't find them to be impressive immediately on their face, usually with some explanation, they could be convinced. When people ask about activities for final merits, like how to bolster the final merits through profile building activities, I am usually telling them quality matters here far more than quantity. Like, this is not the place to emphasize where you have 40 different judging opportunities. It's not the place to emphasize that you have, 100 publications on various different technical blogs, podcasts, articles, and all of that. This is where you emphasize your most prestigious appointments. So if you made it into some membership organization or on some technical committee where that position is admired by other top professionals, that's what you emphasize. If you have a leading job title at a top company that's super, super competitive, that's what you emphasize. If you won a particular award that is objectively prestigious, like not the Globies, not the Nobel, not the Titan, like in your industry, an objectively prestigious award, that's what you emphasize here. I like that approach, Jason. I haven't thought about putting it in those terms before, but it's really valuable, I think, and it definitely comports well with the final merits argument.
So Daryl asks, so is the standard used based on the value of the evidence or the reasonable standard like 4951?
So it's supposed to be. What this person is talking about is the preponderance of the evidence standard, where you only need to prove as the petitioner that you more likely than not have risen to the top of your field. So as long as you prove that 51%, even if the officer has some doubt, like maybe or maybe not you've risen to the top of your field, as long as the weight of the evidence on balance shows that, it's most likely more than 51% probable that you have risen to the top of your field, they are supposed to grant the case. Do they always apply a preponderance of the evidence standard? Definitely not. Like, I have seen so many EB-1A decisions where I'm like, this officer wants clear and convincing evidence. They're almost applying a beyond the reasonable doubt standard sometimes, I think. The proofs that they ask for sometimes are very high. But it's not all officers, it's just some. So you present the best argument you have. You do try to show that it's clear and convincing evidence as much as possible. Like, you don't really want to be in a position where you're saying, well, on 51% chance I should qualify for this benefit. You do want to remove any doubts that the officer has. But you are correct. That is the correct standard. And there's been a lot of successful EB-1A litigation in court because this is the standard. So it's something to pay attention to. Just don't expect USCIS to always be reasonable, because they're not.
Ajay Key asks, generally the final merit story is anchored by how many criterion?
It depends. So sometimes I will use only one or two, and I'll emphasize those points, and then I'll bring in a bunch of quotes from experts, affirming that the person has a reputation for being at the top of their field. It is definitely stronger, though, if you can kind of feed everything together. So there are times where maybe someone's judging an authorship isn't the strongest, but I might make the argument that they're in such and such a position, and that authoring articles and sharing within that industry is pretty rare and indicative of accepted expertise. Plus, they were appointed to these prestigious judging positions. Plus, they've been highlighted in the media. And then I'll tell the officer that they should apply a holistic analysis. And holistically, the person has risen to the top of their field. So generally, I use one or two, but sometimes I do bring in, all six. It depends on what I think makes for a more cohesive story according to the industry the person is working in. Hopefully that makes sense. I'll try to think of an example later on, but we can answer more questions for now.
What is the evidence that is generally provided for proving final merits?
Yeah, so I normally don't include any exhibits for this section. So no evidence in this section that has not otherwise been presented in other parts of the file. I did mention quotes from expert letters. I do think expert letters are very important to the final merits analysis, but I use the expert letters for the criteria analysis as well. So I'll use different quotes from the letters when talking about leading role versus different quotes when I'm talking about final merits. So those exhibits and documents can be referenced in this section, but they're not individual or additional supporting evidence. Final merits is really about pulling everything together that's already in the file to demonstrate that the person has risen to the top of their field. And that's really what I mean when I say it's not an additional criteria. It's not something additional to prove. Instead, it's about bringing everything that you've already presented together and then explaining in a narrative form why you have risen to the top of your field and how the top experts all recognize that and count you among their ranks.
How do you show sustained acclaim?
Mm-hmm. This is another good one because this also factors into the final merits analysis pretty significantly. When looking at the criteria, some people worry too much about sustained acclaim. Like USCIS will grant you the judge criteria even if you have 6 months of judging activities. They will grant you a leading role criteria even if you only have one leading role in the last 4 years or so. So that you don't necessarily need that sustained element when you're looking at each individual criteria. Now, again, some officers will ask for it. So going back to preponderance of the evidence, it's not something they're supposed to do, but some of them will. But on average, most officers will just grant you the criteria because they're doing a straight analysis. And then they save the sustained acclaim for the final merits section. I do think that that's the most appropriate way to go about it, according to the Kazarian decision. And that's the one that governs all of the EB-1A adjudications. But yeah, they will need you to prove sustained acclaim. This is not the time to emphasize all of your most recent things. Instead, it's the time to emphasize how your career has built and accumulated in you being at the top of your field. You don't need to say, I have 10 years of experience. You don't need to say, I have 15 years of leadership in this and this area. Instead, you need to show the progression. So oftentimes I do start at college. So I'll say the person graduated from this prestigious program. They went on to perform many critical roles at this XYZ companies. And now they have proven themselves by making this particular contribution, being highly compensated, being recognized as an expert who is routinely invited to judge this and this, and put it all together in that kind of format. And then, of course, say this expert and this expert all recognize the importance of the person's career. I don't actually often get questions on sustained acclaim. I know it's a trend right now at USCIS, and I think it has to do more with the construction of the case. Like the way we construct the cases, we're trying to avoid that question at each point. So, I mean, you don't need to put elements of sustained acclaim into the criteria analysis, but if you can, why not? So, for example, some classic cases right now are people who have tons of experience. Maybe they have 15, 20 years of experience, sometimes 25, 30 years of experience. And they are highly compensated, but that's really all they had going for them until 6 to 8 months ago when they started profile building. And now they have a profile with judging, maybe authorship, maybe media. So the elements that they've done profile building clearly aren't sustained, but they have a really strong argument for being at the top of their field just based on years of experience and current position. I mean, I don't often even use the phrase sustained acclaim in the case. I mean, it's always mentioned a couple different spots, but I'm not harping on it or relying on it. But I would present leading role first. And I would make that the longest part of the petition. And I'm explaining in that section how the person rose to their level, how many years of experience it took, what the career trajectory was, how their recognition has been sustained for years, and how they've been at the top for years. And then once that's established, sustained acclaim really isn't going to be questioned in the rest of the petition. And so then in final merits, we're just talking about how the person has current recognition as being at the top of their field, and that's usually enough. For people who have less experience, so maybe someone who has 7 years of experience or something like that, it can be harder to do that kind of case without getting questioned on sustained acclaim. I sometimes recommend that people who have that level of experience do the profile building for a couple of years, like 2 years, so that they have more of a track record with judge, more of a track record with membership, and so on and so forth. I think having all of that kind of heads off some of those inquiries. But you also don't need it. Like I said, a lot of officers will approve these cases without questioning sustained acclaim as its own individual thing, as long as you are reasonably demonstrating that you've risen to the top of your field and that you are currently there, at the top.
Andrew asks, do company awards which don't qualify for the awards criteria help in final merits?
Not usually. I would say if there is a particularly prestigious award, maybe that has some industry recognition in addition to being important within the company itself, that could factor into final merits. It might be something that I mentioned that's really rarely the case. I think I may have had 1, maybe 2 cases ever where that kind of factored in. Most of the time I'm claiming the company awards under leading or critical role, and then not really mentioning them again throughout the rest of the case. They would need to be particularly prestigious for me to rely on those in final merits.
Ting asks, I applied for EB-1A and it's denied on sustained acclaim, 3 criteria approved, but I only have 8 years of experience and most achievements are recent. What should I do to build sustained acclaim?
Yeah. So this is kind of similar to the general case I just mentioned. 7 years of experience. Maybe you've only built the criteria for 6 months. Normally, I do recommend a longer timeline. And again, so it wouldn't have been impossible for your case to be approved. So I wouldn't necessarily discourage filing it. I think you're probably fine to file it as long as you have a reasonable claim. But if it was denied, I think you should build the profile up a little bit more. And that means, maybe doing some additional activities that are lower level, like getting a couple more judge roles, maybe publishing a couple more papers. But aside from that, just to keep momentum and to keep things going, you should really be looking for 1 or 2 things that are undeniably prestigious and undeniably recognized within your field. This can be very different depending on the field or the industry that you're in. So going back to the beginning of the conversation, Jason had recommended talking to other top people that you admire in your field, that other people admire in your field, and kind of figuring out what they would find to be impressive. That can be a good start. And then if there are already things that you are aspiring to later in your career, try to push those on a little bit faster. If you are trying to get some kind of leadership role in a professional organization, try and push for that a little bit faster. Put in the groundwork to make that happen. If you do the refile, you will need to kind of address the reasons for denial in the first place. That is very important because USCIS can go in and look at the prior record, and they often do, at least, give a cursory look to the prior record. It's not going to be determinative. Refiles are very, very successful as long as there's a reasonable claim and a reasonable basis, and as long as you put in a little bit more work to build it up. So good luck with that. I definitely think it's attainable even without knowing your case and the specifics of your case. And I'd be happy to talk to you sometime if you want, more targeted advice on that.
Do you find that there is a reticence to grant EB-1A to attorneys even when their experiences roles extend to business and leading roles in organizations?
Yes, I have definitely found this. It's not impossible for an attorney to get an EB-1A. I have seen it happen, but I have also filed cases that were ultimately denied for attorneys. And these are attorneys who did have really extensive roles in business and in shaping both the legal tech field in their country, shaping various aspects of legal practice in their country. So not impossible, and I don't want to discourage attorneys a lot, but I also see a lot of attorney profiles where I'm like, you would really need to build this up in order for it to be accepted. It's not just a matter of serving on a bar committee for a specific field of law. It's not just about running your firm. You would need to prove not only that you are, for example, running your firm, but that your firm, due to your efforts, has a distinguished reputation. That's actually more difficult to show than you would think. Like a lot of the lawyer awards and things that show distinguished reputation run into the same problems as the Globies and the Stevies, where it's all like self-supporting, all the media is from the granting organization, and all of that. And then attorney professional development is often limited to the state bar, which is not great for EB-1A either because it needs to be national acclaim. So it's tough to do for attorneys. Not impossible, but tough.
So I don't see any other questions.
All right. I'm trying to think if there are final thoughts here, things that I've seen come up a lot. I guess I do want to comment on how final merits factors into assessments. I've been running these little roasting workshops for going through people's CVs and realistically saying, okay, do you have a chance? Do you not have a chance? And kind of showing the attorney thought process behind reviewing resumes. A lot of you may be sending out your resumes to various attorneys and getting various points of feedback. Attorneys definitely look at final merits, and they may do it subconsciously, where they might think they're looking for criteria, but really they're looking for final merits. Like a lot of attorneys have benchmarks in their heads, benchmarks in their minds. USCIS officers also do, and everyone's standards are different. Like the attorney standards are different, the officer standards are different. There's no, I shouldn't say there's no bright line. There are guidelines. There's more guardrails on EB-1A than there is on EB-2 and IW, but it can be very arbitrary. And so I tell people all the time, EB-1A is about making an argument. So you have to make the argument to the attorney. If you can convince the attorney can make an argument to the government on your behalf. But everything is about making an argument. It's never about meeting a single bright line standard. And that really matters for final merits because it's so arbitrary. I would keep that in mind.
If the EB-1A application was submitted and all the evidence and support letter indicated the extraordinary ability, but the applicant selected the wrong option under Part 2 of the I-140, should the case be assessed accordingly, or should it have been assessed in the category according to the evidence?
Yeah, this is a tricky question. USCIS could approve it under the part that was selected on the I-140. But if the officer is any good, they will issue an RFE asking for clarification. And in the clarification, you will be able to submit a new page 1 or page 2 of the I-140, checking the correct box and making the argument for the EB-1A category. It can be tricky to fix, and it can definitely cause delays, even if you filed under premium processing. If you filed under regular processing, I may suggest withdrawing and then refiling and just eating the filing fee. But yeah, the forms are really what governs how USCIS sets this up in their system. So if they set it up in the system and you checked the EB-2 and IW box or the EB-1B box, I don't know that the individual adjudicating officer can really go in and change that without receiving from you a new page with the correction on it. So typically they would issue an RFE for that.
Are you actively taking cases for individuals who will be ready to file in 1 year or so?
So I don't usually take the case until the case is ready to file, but I do regularly consult with people along the way. So anytime you need advice on the profile building aspects, you can feel free to schedule a consultation. I also do have the formal EB-1A Strong profile building program if you're interested in more information about that. Otherwise, if you want to continue using all of the materials that I put out online, and just do that, and once you are reasonably certain that you meet at least 3 criteria and have a case you want to proceed with, at that point I can take the case. And you can finish up a couple of profile building activities here and there while we take the case, but I find that if I take it too early, it gets slower and slower and slower, and we just lose momentum. So I'm learning that lesson and only pushing the cases forward so that we can file them in a reasonable amount of time once they are ready to proceed.
So I don't see any other questions.
All right. Thank you so much, everyone, for joining. Have a good evening.
Thanks, everyone.